All right. While that's working slowly for whatever reason, let's kick it off. Welcome to the Alternative Investing Club. Today is December 6th, 2024, and it's near the end of the year, and so it's a good time. We had a person come in and talk about taxes earlier, and now we're going to come in with the topic of estate planning. And today we have with us Meredith Williamson. Welcome to the group here.
Thank you.
And Meredith is actually here in Hillsborough or Beaverton, perhaps. Or you're right on the border, aren't you?
Yep, I am.
Okay. And so, particularly for those of you who are coming to us from Portland, which as of last week, when we did kind of informal survey, I guess is now the majority group, surpassing the Folsom, California group. So, in particular, if you want to reach out to her and you're in that area, feel free to do so. But also, we're going to have a large question and answer time during this period as well. So, Meredith, welcome here. Can you tell us a little bit about yourself, how you got started, and a little bit about your firm, and then continue on? Oh,
Yeah, absolutely.
one other
So,
thing, too. Do you want me
many,
to interrupt you and ask questions during your talk, or do you want me to hold them to the end?
what do people generally prefer? Because I'm kind of open to
We
either.
usually interrupt like two or three times and
Okay.
then do some at the end.
Okay. I'm
Tends to
perfectly
be the
fine with
normal
that.
pattern. Okay.
Yeah.
Floor is yours.
All right. Hi, everybody. My name is Meredith Williamson. I am an attorney licensed, actually, Oregon, Washington, and California, but I am only actively practicing in Oregon and Washington right now. So most of my presentation will focus sort of on general estate planning and then a little bit specifically for Oregon and Washington. I might defer any questions you have in other states just to a local attorney in those states. So, but I can speak to general matters most definitely. I have had Northwest Estate Law now for almost 10 years. I've been an attorney for over 20, and I focus primarily here in Oregon, Washington on estate planning with a focus also on elder law. So estate planning is going to cover like the planning piece of it. Elder law really covers, in the event that somebody didn't plan or plan well, and now we need somebody to come in and kind of help out. So moving into my presentation. Oh, do you want me to share or I can? Okay. Let me just do a quick share here.
And I'll monitor the chat for you so you don't have to look at it. And that's where we'll get our questions. And so you can concentrate on your presentation rather than the
Okay.
chat.
That sounds perfect. Oops, I lost the share button. And I will say that the reason, while I'm pulling this up, the reason I got into estate planning is because it is an area where I feel like I can really make a difference in people's lives. I get to speak with people, of all economics and backgrounds, and it's a really fun, industry where like get to use sort of the ability to speak with people and help explain to them what their options are. Can you see, is it sharing properly? Okay. So the first thing I'm going to kind of describe is exactly what is estate planning, because it does vary, but there's typically four things involved. One is our legacy planning. Legacy planning is sort of what happens after we pass away, right? Where do our assets go? How do we want them structured? But it also really involves what I think is more important, which is the incapacity planning. So oftentimes people, can get dementia or have some issue where they need somebody to step in during their lifetime. That is done through power of attorney or advanced directives, medical advanced directives. And then healthcare long-term care planning. So what does that look like if we have a degenerative disease or something that we may need help with in the future, or if we're helping a loved one? And then also incorporated in is a little bit of tax planning for people who need that. And we can accomplish that through some irrevocable trusts or working with some financial planners, just really figuring out ways to not pay more than your fair share of taxes. So primarily, the goals of estate planning are to reduce conflict between you and loved ones, or more importantly, potentially loved ones after you pass away. It also makes administration of your estate less expensive, right? So if we put the people into position, we describe how we want our assets to be distributed, that should make the entire process a little easier. And then again, hopefully with a little bit of that tax savings. So some basic questions that I get asked and are important to know is sort of how assets transfer. Anything that you own jointly with another person, that might be a spouse, it might be with business partners, typically, any jointly held assets will go to the joint owner upon your passing. So it's usually just an automatic right. Beneficiary designations will go just straight to your beneficiary on the presentation of some paperwork and a death certificate. Assets held in a trust, and we'll talk about trusts later, but assets held in a trust will be distributed according to the terms of that trust. And then anything that doesn't have that jointly held asset, or maybe descriptions in like business documents or in a trust, will be distributed pursuant to probate. Things that we really need to consider involve beneficiaries. Who's going to be receiving your assets? Do they need any special protections? Are they spendthrifts? Do they have something where the money would be at risk if they were to receive it, or on disability, things that we would not want them to lose should they receive assets. So a really good conversation about who your beneficiaries are. And then a continued beneficiary discussion is, what happens if that beneficiary passes away before you? Where would those assets go? And the really cool thing about estate planning is we can do it in percentages, we can give dollar amounts. It really can be who and where and how you want your assets to be distributed when you pass away. Things to consider are whether or not our estates are taxable. So there is a federal exclusion amount, which is well over 13 million right now. Certain other states do have taxation on top of the federal tax. So in Oregon, ours is quite low. The first $1 million is excluded. Anything other than that is taxable in our state. Washington, 2.19 million. Theirs at least adjusts a little. Oregon does not adjust. It's been $1 million for as long as I've been doing this. And that means the first $1 million, our state is not going to look at to assess a tax after you pass away. Anything else in the gross estate will actually be considered as available for tax in our state. So stuff you've already paid taxes on, stuff beneficiaries will pay taxes on later. Oregon really wants to get their estate tax out of that too. So that estate tax kind of takes a look at all the assets that you have at the time you pass away. And that's going to be everything from cash to real estate to personal property, life insurance benefits. So it really encompasses a lot to be included in that gross estate. Residents are taxed on both property owned here, and non-residents are also taxed on property owned here. So anytime we're over that $1 million, there needs to be an Oregon estate tax form filed. And I encourage people to work with accountants that specialize in this. There are some deductions, there are some tax things that we can do to incorporate it into your estate planning, even at just sort of a basic estate planning level, that helps alleviate a little bit of these taxes. But yeah, unfortunately, especially Oregon here, it really starts to tax at a pretty low amount. Have one piece of property and some money in maybe a retirement account, and it's pretty easy to get to that $1 million mark without even realizing you're there with the value that property is right now in our state. Oregon has a graduating tax rate for estates, and it's the first $1 million again is exempted. Starting a dollar over $1 million, you're looking at a graduating tax rate from 10% to 16%. So it's not an extremely high percentage for a tax rate, but again, it's if we can avoid some of that, all the better. Washington also has a graduating tax rate. So that first 2.19 million excluded, anything above that is going to have a graduating tax rate of 10 to 20%. If you are federally taxable, that will be a federal tax on top of the estate tax. There are certain benefits though. So if we pass finances to our heirs, as part of our estate plan, the main tax advantage we get in waiting till after death is there is a step up in basis for certain assets. So those assets would be definitely real estate, brokerage accounts, anything where there's a tax basis and then you would pay capital gains on it. When you inherit property or when you're leaving assets to your heirs through estate planning, after you pass away, they'll get a new basis. So if you purchase something for $100,000 and it's worth $1 million now, if you were to sell it, you would pay capital gains on that growth. If your heirs inherit it at $1 million and they sell it right away, there's no capital gains tax. And so this is really our biggest tax advantage right now in the estate world in general. Probably one of the biggest tax advantages in general is this step up in basis. And we really, when we're doing estate planning, we don't want to trade like one estate, one tax for another, because this one can be a great big tax savings. In Oregon, if we gift property during lifetime, the people that we gift it to will receive it at our old tax basis. So if you give real estate to a child, let's say, before you pass away, because you're trying to avoid estate taxes, they may end up paying huge capital gains because it would be the same amount, that capital gain that you would have had too. So it is often better to at least have this conversation as incorporated into the estate plan, especially when we're talking about taxes on larger estates. There's also deductions. So there's, deductions for charitable giving. Anybody ever has charity as part of what they're planning in an estate plan, great. It affords a lot of flexibility. We may still have to file a tax return, or the accountant would still have to file a tax return, but similar to deductions during lifetime, there may be deductions after we pass away. And then there are some provisions for spouses. So a married couple will be able to preserve, with estate planning, each of the spouses' exemption amount. So again, in Oregon, that's $1 million, right? So if I were married, I would have, and I died first, we could preserve my $1 million exemption by setting it aside in a trust that my husband could utilize for certain things, but he would not have all control over that. We are then preserving those assets in that trust, that predeceased spouse's trust. He would still have a trust in his name, hopefully with another $1 million in it. So when he were to pass away, my heirs would have my $1 million exemption and his $1 million exemption. That at least bumps it up to that $2 million. The same can be done federally, same can be done in Washington. Federal does allow for portability. So again, working with a really good accountant, if you're over that federal maximum, that federal threshold is a great idea. So basics for the estate plan, at the very least, everybody should have a last will and testament. We should do some memorial planning and potentially, especially for this group, probably have a revocable living trust. And I will talk about what sort of the differences are. So In each state, there's rules for how our assets will be distributed when we pass away. We have the ability to change those, though, right, through estate planning documents such as a will. If we don't have a will, our assets will be distributed through intestate succession. So, operation of law, I pass away, it goes to my children or it goes to my spouse, right? And that is going to be state specific. We can change that though. So within the walls of a will, we can state how you want, we want your assets to go to and in what way they'll be distributed. For Oregon, a will has to be in writing. Some states like California allow for a holographic will, which is handwritten. Oregon doesn't really allow that. Person has to have the ability to sign, so we can't wait till somebody loses capacity. And we need witnesses. Here in Oregon, 2 witnesses who can be anybody over the age of 18 with their own capacity. In Washington, it requires that we utilize somebody who's maybe not named in the will, or else there's potential for a claim of duress. So, and duress is just when somebody forces you, or somebody is heavy-handed in their encouragement on getting you to sign an estate planning document. So the will is going to outline a few things. One, it's going to waive bond, hopefully. So that means that we don't have to have insurance in order to take a will through probate, which in Oregon we would need to have without that waiver. It's going to nominate your personal representative. Other states call this person an executor. This is the person who will work with the lawyer to take the will through the probate process, which is a court process, where assets are used to pay off our bills, do taxes, and then finally distributed to our heirs. But that personal representative plays a crucial role. We want somebody who has the ability to follow direction, to manage their own checkbook. People who will definitely abide by and keep the process moving forward so that your heirs can eventually get your assets. A will does not, again, avoid probate, right? It does make probate easier. It does make probate less expensive. A will definitely allows your assets to be distributed in the manner you want them to. So again, if you have a beneficiary with maybe some special needs, or you want to give it to charities, or have a whole page of people you want to give it to, probate, a will allows you to do that. The will still does go through probate, though. The goal with probate is to cut off creditors' rights, right? So for some estates, we really do want it to go through probate. If we have large creditors, or in some cases of like doctors or lawyers, any area where there's potential litigation, sometimes we still want probate to happen. But the goal is to get it through, pay off creditors, cut off creditor rights, and then distribute assets. In Oregon, probate averages 9 to 12 months. Ways to avoid probate are to hold property jointly, but again, we want to make sure we're not accidentally giving a gift during lifetime. So if you're holding property with somebody other than a spouse, have a lawyer involved at least to know what potential pitfalls are. Also, problem with joint property is everybody owns it, right? If somebody were to get into an accident or need long-term care, your property could be at risk had you given it to somebody to avoid probate only. Beneficiary designations. So most likely on the 401ks, we want things to be by beneficiary designation. You do that at the bank. You nominate who you want it to go to, who that asset is to go to when you pass away. And sort of the thing I like best is trusts. Revocable living trust primarily, but there are other trusts that we can incorporate into your estate plan to avoid probate, to reduce taxes, to make distributions the way you intend them to go. Talking briefly about the revocable living trust, this is the primary trust that is utilized in estate planning purposes. There are definitely other trusts, but at the very least, we want somebody to have a will and potentially a revocable living trust. This is a unique document. So, a trust is an entity that exists both during our lifetime and then after we pass away. Definitely avoids probate. It is managed by a trustee. And a trustee is most likely, with a revocable living trust, going to be you during your lifetime. So long as you have capacity to manage your own affairs and want to manage your own affairs. You would also nominate successor trustees. So these are backups to you. Obviously, we need a backup when the person passes away, becomes incapacitated. And then if we have ongoing trusts, meaning if we, within the walls of our documents, have outlined new trusts for our beneficiaries, we need trustees to manage those trusts too. Advantages of a trust is just that management, right? Easy, everything hopefully is in one place. We do keep certain assets like 401ks, IRAs, some annuities will stay outside of the trust, but for the most part, all cash accounts, brokerage accounts, real property, even ownership in some businesses, we want to be included in that trust. It protects our children. One of the main disadvantages in my eyes about probate is that it's public, right? It's out there. Anybody can get on the court sites, probably throughout the country, and look to see what is happening in a probate. That means everybody knows how much a child is getting potentially out of that estate plan. We can avoid that completely by creating a revocable living trust. There is that marital allowance, right, that we talked about earlier in trusts that are a little easier to set up. We can do it in a will, but unfortunately, if we do it in a will, we need to probate on the first to pass. And in my eyes, that's not ideal. Some states may see differently, right? Every state is manages estate planning different. But in Oregon, I don't like that. Yeah, and then protection. So I'm not even sure if this is true, but in my mind, it is a lot harder to access a trust account at a bank than it is if somebody just, prepares a power of attorney, drafted it online, got mom to sign it, all of a sudden they can be agent on mom's bank account. I don't love that for my clients. I don't love that for anybody unless, the person that is acting as the agent is doing the right thing. Adding a trustee, adding it into the trust, the person has to be a trustee to access that account. We can't have a trust account with an agent on it. It has to be the trustee. So it does, in my mind, actually, provide a little extra protection as we age and enter sort of that long-term care post retirement needs. Speedier distribution, usually we can get trusts done pretty quickly, or at least an initial distribution. We might still have taxes, right? And those can take a long time. We still need to manage assets, maybe sell real property before distributions are made, but distributions can be over time. They don't have to be all at once, whereas probate, we really wait till the end of probate, typically, to make distributions. We can also manage out-of-state property. So if you own property in more than one state, a trust is really a great vehicle, because what we don't want is probate in multiple states, right? That's multiple courts, multiple agents, kind of a pain. So if you do own property in more than one state, talk to a lawyer about a revocable trust. And then hopefully, my whole part of my idea of what I'm helping people with in this industry is avoiding disputes. There is just something really hard about money and death, that combination, right? Death is hard, and then talking about money is hard, and people will often focus on the money instead of the real pain of the loss of a loved one. And it's just easier to have disputes resolved quicker or avoid disputes completely through a beautiful no contest provision in your documents. So in my mind, again, it helps with that, right? Trust is not for everybody though, so you really want to work with an estate planning attorney and financial advisor just to figure out if this is an ideal vehicle for you. If you're not going to complete the funding, right? If you're not going to move those assets into the trust, then you're going to be looking at having this beautifully drafted document and potentially still going through probate for your heirs after you pass away. So funding is important. Making sure you keep up with it is important. It shouldn't cost you for a typical revocable living trust. It shouldn't cost you an ongoing annual fee unless your attorney has a maintenance plan, which some people really, really enjoy. But for the most part, right, it's just making changes as your family or life situation changes, but keeping it funded is vitally important. So as you purchase new property, right, we gotta make sure that that property is put into the trust. We can take maybe a break here if there's questions about the estate piece of it.
Excellent. Yeah, this is actually a great time to stop. Quite a few questions on multi-state situations.
Okay.
And I will just start up at the top here. And actually, I'll ask this one first. If you are living in Oregon, but you have a state set up or a trust set up in a different state, like California or somewhere else, where is who has jurisdiction?
Ah, great question. So I would encourage depends on the trust itself, right? So the trust is going to tell you everything you need to know. The trust can change what we call the situs of the trust. So jurisdiction most likely is going to be in the state that the trust was created. That will be where, the trust will probably refer directly to the laws of the state in which you created it. When you're moving from a state like California or Washington, they're community property states. Oregon is not. So there might be advantages or disadvantages to having it in one state or another. Typically, though, if you move, it's a good time to revisit the plan. You don't need to start over. But typically we will do something called a restatement to the trust. So we're taking that old trust and just revisiting it completely, right? And in that, we're changing the situs or the jurisdiction of the trust as well. Trustees can be anywhere in the United States. So we don't need, when you're picking a trustee, it doesn't have to be somebody in the state that you live, because families are just everywhere now. So jurisdiction would probably still be in Oregon, even if your trustee was Montana or something.
Okay. Here's a question from PG. What if the estate holder and beneficiary live in different states? Who pays the taxes?
Ah, great question. So it is the estate that pays the taxes. In Oregon, Washington, federal, it's the estate. So that means before it goes to the beneficiaries, before we make those distributions, your estate is paying the taxes. So yeah, it's the estate, and so it doesn't matter what state they're in. It matters where you passed away or had property when you died.
All right. HH is asking, and I happen to know that's Henry, so I'll just say Henry's asking. Um, Examples like brokerage accounts.
Mhm.
Is it best to have it in a trust, meaning the trust is the owner of the account, or is it better to have the trust as a beneficiary?
So some of this is going to all depend on your exact situation, but for me, generally speaking, I like whatever assets that can be moved into the trust to be in the trust. And it puts a little more work on you during your lifetime to retitle it, to get it in the name of the trust, but it's one less step for your beneficiaries after you pass away, right? So if the trust is the beneficiary, then we got to get it moved into the trust, and then for the trust to control it after you pass. If we can just make one less step for the successor trustee by having it already kind of preloaded in there, I like that option, generally speaking, better.
All right. Ben Lee is asking, how do the limits, you mentioned the $1 million limit, I assume is what he's talking about in Oregon, apply if assets are in multiple states?
Yeah, so there's a calculation. And if you have, and it depends on how much tax you're paying elsewhere, right? Because you're not going to get double taxed for the same thing, or you shouldn't be. But if you have assets in Oregon, even if you live outside of Oregon, you're likely still paying some estate tax. If you have property in other states, Oregon's going to pull that in, but you're not going to. But there's a calculation; it's not dollar for dollar the same amount, but it is part of that consideration, unfortunately.
Okay. Let's see here. We've got a lot of questions coming in now. More are going into the chat. Let's see. When you moved, this is from Jellen. When you move to another state, do you have to redraft the entire estate plan, or does it carry or modify any parts of the existing documents? And I might add an addendum to that. Can you set up your trust in a state in which you don't live? Is there any reason you'd want to do that?
Yes. So again, you want to we will always want to use your initial trust because you have funded it, hopefully, right? So we will always refer back to the original trust that you created. But typically, if you're working with a new lawyer, we don't like to take on the risk that your last lawyer did something wrong. So we're going to do something called a restatement, which is sort of like creating a brand new document, but it's still referring back to that old one. So you don't have to refund it, which is the benefit. The downside is you're paying another lawyer to kind of restate the same thing again. And you can create, sometimes people do want trusts in other states. There's Delaware trusts, right? There's states that have more favorable tax laws for certain assets. So there are sometimes reasons why you would want to work with an attorney in a state other than the state you live for certain types of trusts. Yes.
Okay. I'm going to summarize a couple of questions into one, and that is, can you put a 401k or term life insurance and term life insurance into a trust?
Yep. So you do not want to, so no is the easy answer for the 401k. We don't want, we would have to cash it out, right? Because the 401k, anything that has not had taxes come out of it yet, would have to be cashed out with that entity change by changing it from yourself to your trust. So we don't fund it into the trust. Now, there are ways, depending on what your goals are. So this is where it becomes important. There might be reason to leave a trust as a beneficiary on a 401k. And primarily I look at that for protection of beneficiaries. If a beneficiary is on SSI or, is a complete spendthrift, sometimes paying a little taxes in order to protect the beneficiary is the better option. But we don't do that ever during our lifetime. With life insurance, typically in a general plan, we will just have you put the trust as the beneficiary. There are, however, some really cool life insurance trusts that are coming up later in the presentation, but I'll just address it now. Because the value of our life insurance is part of our gross taxable estate, right? It goes toward that $1 million limit. If we have it in an irrevocable life insurance trust and the trust owns it, so it can do that, then it is outside of our estate when we pass away. And that sort of goes, usually we use it to pay some estate taxes and then the rest can go to beneficiaries. But it doesn't increase your tax burden then. So I love the ILETs, they're called ILETs, as an option as part of your estate planning. But yeah, typically we'll just do beneficiary designations on life insurance. You can do it to beneficiaries again, depending on, who the beneficiaries are, age, kind of what you have concerns with for your beneficiaries. So it's all part of a good discussion with your attorney.
Okay, I'm going to let you know what's coming up in terms of questions and then let you move on to your presentation.
Okay.
So we do have questions around asset protection versus
Okay.
trusts. In particular, I do like the question: is a trust better than a prenup when you want to protect your assets? Um, but and then the other category is uh, how does this affect a mortgage if I move my house into it? And
Okay.
I'll just let you. You can either answer that now or go on to your presentation and we'll revisit it later. But I do want to ask one question
Yeah.
first. What does it mean to fund a trust? What
Oh,
does that mean?
perfect. Yeah, so funding or retitling of assets. So we have this beautiful trust, right? It's created, I'm sure it's drafted just magically exactly how you want it, but it's just a document, right? It's really just like a contract that you're creating with yourself. You're the settlor, which is the person creating the trust, also called trustor or grantor in certain states. You're the trustee, which is the manager of the trust, and you're the beneficiary until you pass. But the trust document is only so good as your assets being kind of within it, or the trust being able to control those assets. And the way a trust can control those assets is by moving them into the trust. And we do that through, like with real property, we execute new deeds, right? So we move it from your name individually to you as trustee of your trust. Personal property, business assets, we can do, with signatures and moving assets in. The bank, you need to go to the bank and you need to take something called a certificate of trust to the bank, and the bank will actually, depending on the bank, close your old estate and open a brand, or close your old account and open a brand new account in the name of the trust, or just move that account into the trust. But yeah, we need like your checkbooks to say, your name, trustee of your trust, and that way we know it's in there. So it's really just a matter of taking it from just you to you as manager or trustee of your trust. Financial planners, all that usually get involved, again, using that certificate of trust. This is a
Oh,
good place to talk about the mortgage, though,
okay.
because I just talked about, we create a new deed and move it into the trust. So with your primary residence, there's a safe harbor rule. So even though there is a due on sale clause, most likely in all of your mortgage statements, right? And due on sale is usually any type of transfer. So that means the mortgage can get called due if we transfer it to another person, another entity. If it's your primary residence, that's never a risk. They cannot call your loan due because you move it into a revocable trust. Now, an irrevocable trust might be different, but a revocable living trust, this standard estate planning document, loans can't be called due. Now, technically, any investment property, that safe harbor doesn't apply, but we can avoid the due on sale clause by either letting the mortgage company know ahead of time, right? That's the safest. Like, hey, I have this trust, it's revocable. If you want to check it out and see that I'm not, sheltering it, I'm just using this as a probate avoidance. They typically will be, just fine with it. As far as, also, I've never had one that's actually been called due. So you can risk it and then say, oh, my bad, or we can ahead of time talk to the mortgage company and just get approval, which I've never had one denied either.
All right. I'll let you continue on with your presentation.
Okay.
And I guess there's also some life insurance questions that are coming up as well.
Okay. We open that. Okay. Perfect. So more importantly than like our stuff, right, or the legacy, the finances that we're leaving behind, what happens if during your lifetime you are incapable of managing your own affairs, whether that is financial or healthcare decisions? So I always incorporate this incapacity planning, potential incapacity planning into my estate planning documents because I see them as kind of even more vital, right? We need to make sure the businesses continue to run or are sold to pay for care. And this is primarily done through a power of attorney. For financial, we want to make sure that that power of attorney is durable. And what that means is that when you need it, your agent has authority to make decisions. So durable just means that even if a person is incapacitated, that power of attorney is still valid. Sometimes we use power of attorneys in business for like limited reasons, right? Those probably we don't want durable. But when we're doing it as part of an overall estate plan, this incapacity planning absolutely has to be durable power of attorney. And then there's healthcare planning, right? And some states will do this through a healthcare power of attorney. Oregon does it through an advanced directive. Some states use a fabulous document called 5 Wishes. So these are all tools where we're putting somebody into position to make healthcare decisions for us in the event we can't make them ourselves, either temporarily or permanently, right? So to me, this is the most important planning, that and like guardianship stuff, right? If we pass away and we have children who are minors, who's raising them? So the power of attorney avoids the need for a conservatorship. So I talked about the fact that I am also an elder law attorney. An elder law attorney focuses on long-term care planning, but also on conservatorships and guardianships. And that is, again, a court involvement. If somebody needs help with their finances, we need to appoint a person. Without a durable power of attorney, we're looking at the court getting involved and overseeing everything, which has its positives, but is also quite cumbersome and expensive and public, right? None of those things are great. So if we can avoid the need for court involvement of a conservatorship through a well-drafted power of attorney that costs, either part of your estate plan or not that much money compared to an ongoing conservatorship, right, let's do it. Every single person needs a power of attorney who's over the age of 18. Upside of all of these documents that I've talked about so far is that as our needs change or people in our lives change, right, all these documents so far are revisable and revocable. So it's not like you put this person into position and you can never change it. Power of attorneys are only good during our lifetime. So as soon as we pass away, all the agent's authority under the power of attorney go away too. And that's where if we don't have a trust that sort of straddles life and death, then we need to look at the will, right, as the vehicle to get a hold of the assets. But we always do a power of attorney at the same time, even if we're doing a trust, because like we talked about, some of those assets, like the retirement accounts, will be still outside of the trust. Healthcare documents, these will avoid the need for a guardianship or guardian of the person in some states. But basically, again, like the court getting involved, adding the person to be in charge of you to make healthcare decisions during your lifetime. This can include everything from, whether or not you're having surgery or placement in long-term care, but it can also include end-of-life decisions. So I believe most states have something along the lines of this advanced directive piece of it, giving your healthcare agent a little bit of pre-instruction on what you think you would want them to decide for tube feeding and life support if you're faced with it and can't make your own medical decisions. Again, revisable, revocable, not set in stone, but you want somebody in this role who can emotionally handle making such decisions for you. Other planning options. So the cool thing, what we've talked about so far is sort of like the general plan that, depending on the state you live, I like, right? I like the revocable trust. You got lots of control during your lifetime. Will, always. Power of attorney, advanced directive, always. But what if we have specific assets, right, that need to be handled in a certain way? You can really craft trusts to manage those type of assets. So maybe it's guns that need to transfer. Maybe it's, a pet that needs our help, or that we want to leave extra money to, and somebody to manage that pet and their health care. Great, let's do a pet trust. Residential trusts. Sometimes we use residential trusts. Sometimes we'll do it through an LLC or a combination of both, but managing real estate. Also trusts for certain beneficiaries. So with disabled beneficiaries, if they're on SSI, and we give them money, there is a huge risk that they will lose their benefits. And it's probably not the $1,000 a month that matters that they lose, but it's all those other resources, all those other things that go along with it. Maybe it's, medical or group home. We don't want them to lose that. But it doesn't mean you need to cut them out of your estate plan. It means we need to set up a special needs trust for them. Third party is if it's like grandma and grandpa, mom or dad leaving it to a disabled person. A person can also set up a first party special needs trust or supplemental needs trust in some states for themselves. So it's a great way to manage assets without benefit loss, especially if we're leaving assets to them as part of our estate plan. There's also some cool things we can do for taxable estates. So charitable trusts, the ILIT, right? The irrevocable life insurance trust, which it sounds like we're going to talk a little bit more about. So I'll scooch past this. These are all really cool things that we can do for preserving, right? Or helping to manage some of our estate during our lifetime. The only way to avoid taxes is to get it, remove the property from our control. I personally don't love to give up control of basically anything. So it's not something I would do right now in my at my age and how old my kids are. But over time, right, I may want to give some assets. Again, we need to look at making sure we're not giving up one tax in exchange for another, but setting up irrevocable trusts on behalf of other beneficiaries, looking at an ILIT, which is that life insurance trust, to pay for taxes and to get, the life insurance out of our estate. A lot of different options, which really don't apply to the majority of people, but are great tools to talk about, as you're looking at your estate plan. What I don't want to have happen though, and I see some people get like, they want to go for like these really complicated plans right off the bat, and then it's 4 more years because they get scared and they haven't thought it through, and now they don't even have a power of attorney. Don't do that. Like, at least get a basic plan, at least get your power of attorney, get some stuff together, and then and during that have a conversation with your lawyer about these other plans, right? We want to incorporate it all, but we don't want to get stuck on the advanced plan to such a degree that we haven't done the basic plan and now you're incapacitated or somebody has passed away. We really want to make sure that we're getting sort of these basics done with the knowledge that there's these other really cool trusts that we can accomplish at the same time. All right, do you want to break for questions too?
We have so many good questions that I may actually have to re-listen to your talk because I've been sorting through and organizing and trying to figure out which ones would be most generally applicable.
Okay.
I'm going to ask you, I have a couple of them that I think could be answered in short responses. So I'm going to rapid fire a couple at you. Can you do short responses?
Yeah, I'll try. I'm a lawyer, it's hard.
Can you have a trust that holds property outside the U.S.? A U.S.-based trust that holds property outside the U.S.?
Depends on the other country, Yeah, typically we want to do it in multiple countries then.
Okay. We have 2 questions around what accounts would I not want to have at a trust, and how do I tell?
What was the second part of it? Sorry.
What should I look for on deciding whether they should be put in the trust?
Oh, okay. So anything that's going to have a tax consequence of like anything that has your life in being, right? Like it requires your age and gender and whatever in order to make distributions down the line, that does not go in the trust. Typically, some annuities, right? That all aren't going to go into the trust. If we can do something through a beneficiary designation and the beneficiaries are appropriate to receive that designation, it can be out of the trust. But for the most part, like generally we want as much as we can in the trust, and then we can always incorporate other things into your plan using beneficiary designations too.
I love this question. For kids heading out to college, other than a power of attorney, what would you recommend the parents keep handy?
Yeah, I mean, power of attorney for sure, healthcare for sure. Um, when we're just established, like, we don't probably need a trust unless we're setting up like an irrevocable trust for them. But for the kids themselves, you know, the youngest person I did an estate plan for was their parents purchased it for them on their 18th birthday. Super cool, right? And now hopefully they don't need to think about it till they have kids of their own. Um, but really, it's that lifetime, those lifetime documents, 100%. We need power of attorney, advance directive, healthcare power of attorney.
All right. Let's see here. This one I think is going to be important for when you give, and feel free to put your contact information up on the screen if you have
Oh,
that.
okay.
For anybody who would like to reach out to Meredith. And I'm sure this question may affect that, but a couple of people have asked, do you take the MetLife legal plan for consultation?
Yeah, unfortunately, I don't right now. And I know that's through like Intel uses it. So I don't. I can do a 15-minute free consultation though for estate planning. And I think they have a list there of the MetLife attorneys.
Okay. Okay, great. Let's see here. We have for those that are not in Oregon. Okay, this is two questions combined. There's one person that wants a recommendation on a California estate planner.
Okay.
And then the follow-up kind of that is another question. For those that are not in Oregon, how would you vet a lawyer for
Ooh,
this?
good question. Okay. So first, I would use an estate planning attorney first, right? So there's a couple different places that you can find estate planning attorneys. But typically through the bar, so the Oregon State Bar, Washington State Bar, California State Bar, they're going to have lists of all the attorneys. I would interview some because this is an area you want to make sure that you are comfortable with the attorney. You are sharing really detailed decisions and circumstances about your family with that attorney. You want to make sure they listen to you. So not only have the background of estate planning or elder law or tax or whatever it is that your primary goal is, right? But we want to make sure that you are comfortable telling them all of the pluses and minuses of your family, your circumstances, your goals. So somebody's not going to rush through the consultation with you just to move on, right? It's really important. I want people to feel comfortable with me, and I would recommend, calling around until you feel comfortable with the attorney that you're speaking to.
Bo is offering some information here. Apparently, Freddie and Fannie Mac, the government lending
Mhm.
agencies, have. Sorry about this. It's my alarm for my next meeting. Um, they've created rules that say help that say to banks that you should be allowed to move your house into a trust. So apparently there are definite regulations around that. And I just lost my train of thought here. Let's see. Where? Sorry. Oh, if you have a property that is co-owned with your spouse and one of you passes away, does it go to estate planning or does that spouse inherit the other part of it?
Yeah, so with a married couple, it is typically we purchase it with right of survivorship, so that jointly held tenants by the entirety. It would go straight to your spouse. But I would prefer that you and your spouse have it in a trust, because what if something happened to you together or close in time, right? We want to make sure that if it was something like a car accident, that it doesn't have to go through probate. So even though it's jointly held, it's one of those ways that we avoid probate. Still better to have some other vehicle for it to get into, such as the trust, to your next in line heirs without probate.
All right, and two questions that will be for potential incoming clients, I suppose. If we already have an estate plan or a trust in an estate plan, is what they say here in Oregon, do you offer services where you would review it?
That's the tough one, right? We don't want to take on, lawyers don't like taking on other lawyers
Yeah.
issues. But yeah, I mean, definitely if your attorney retired or passed away, or you just kind of didn't enjoy working with them, it is good to have an attorney that you do enjoy working with. So even if it's not a complete review, just again, one of those 15-minute free consultations, or just to make sure that it meets all those legal definitions that we need those documents to have in order to be valid. But it is good to have an attorney, and one that you're comfortable again working with. And I never answered that prenuptial question, so if you don't mind.
Go ahead.
Okay. So I love a prenup for everybody, right? You're having a really tough conversation before you get married. Better to have it before you get married than after. Can avoid some some issues down the road, but I like the combination of it, right? So the prenuptial agreement you're going to enter into before you get married. You're going to have a conversation. You're going to outline all of your assets on both sides and say what your intent is. You should then follow it up with your estate planning documents. The estate plan should incorporate the language of that prenuptial agreement. If it doesn't, and it says something different than your prenuptial agreement, then the court will probably treat it like it's a new agreement, right? But it is good. Love them, especially if there's kids from a prior relationship. But then estate planning documents definitely add that second layer of, oh yeah, we still meant this, right? It's good to have both.
All right, we're up at the top of the hour, so it's that time. Can everybody take themselves off of mute and thank Meredith for coming in and speaking to us today?
Thank you very much.
Thank you, Meredith.
you.
Meredith.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you so much.
Thank you.
Thank you.
Great job. Thank you, Meredith. I want you to know we actually had a limit of 100 people in this particular call, and so we ran into that limit. It stayed there almost the entire time. So I'm going to commit to everybody here to post the recording of this at the Alternative Investing Club website by this afternoon. So thank you, everyone, for being here. Thank you, Meredith.
Thank you.
That was great. And we will see you all at the beginning of next year, not next week. So we're going to have 2 weeks with no club, and we'll see you all in the new year. Have a wonderful holiday, everyone. And you too, Meredith. Have a wonderful holiday.